Good morning and welcome to today's webinar, Trustee Selection and How to Choose the Right One for You, presented by Elville and Associates Managing Principal and Lead Attorney Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and I'll be moderating today's event. So welcome to those that are new to our educational webinar series, and also to those that are frequent attendees, welcome back. If and when you have questions, please note them in the questions panel on your screen, and we'll take time throughout, as always, to address them. Your questions really help the presentation, they add value, and help others learn, so don't be shy in posing your questions at any time. You received the presentation by email from me to take notes on it if you wish. It's also available in the section marked handouts on your screen to download at this time. For our professionals on the presentation, welcome as well. For CFPs, CPAs, and others, you may receive 1.5 continuing education hours for attending. And per my attendance records requirements, please email me your ID number as soon as possible so I can submit your CE hours for approval. Everyone will also receive a post-webinar feedback email right after the presentation, and we ask that you please just take a couple minutes to fill out this very brief survey to offer us your feedback about the presentation. Here at Elville & Associates, we always want to be a resource to you here for your families and your planning needs. So consider a consultation or a document review with Steve after today's presentation, and use today's education as a jumping off point to get your planning started or updated. Consultations are a great way to get your specific questions answered, have Steve understand your individual situation, and help create solutions and a path forward for you. So I'd like to offer Steve and the firm a proper introduction before we get started. And then we have a very brief poll, and then Steve is going to go ahead and jump into the presentation. This is always one of our more popular presentations here at the firm we offer on a quarterly basis. Elville & Associates, let me share my screen first of all. There we go. Elville & Associates, we were founded in 2010 by Stephen Elville. We have several different practice areas here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, tax planning and asset protection. We have 7 attorneys, 12 staff members in 5 different locations. Steve and I are coming to you live from the Columbia Gateway Community location today. Our mission, as it always has been and always will be, to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. And we do focus on education a lot here at Elville & Associates. We do that in several ways through our planning processes with our clients. We offer over 100 educational webinars and workshops in the communities that we serve each year, and also through our accredited client care program, or CCP as we call it. We're one of only 2 firms in the state of Maryland to have an accredited CCP through the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion in mind with every client every day here at Elville & Associates. A little bit about Steve. His work as an attorney for the past 20 plus years has been centered in elder law, special needs planning, and estate planning, with an emphasis in the areas of tax planning and asset protection. A member of many different national membership organizations, the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. He works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. A very seasoned speaker. If you haven't heard Steve present before, presenting at many webinars, workshops for businesses and their employees, conferences, and continuing education events. Steve was also named to the Maryland Super Lawyers list for an 8th time in 2023 and a 7th consecutive year, so congratulations to Steve. He also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014. I'm privileged to be the executive director of. So if you'd like to learn how we are making a musical difference in the lives of children each day, please reach out to me and I'd be very happy to share our story with you when we have just a little bit more time. But for now, we're going to talk about trustee selection, a very important topic and one that Steve knows a lot about. Before we do that though, we're going to learn a little bit about you and what brought you here today. And our question for you today is, what has brought you to today's webinar? And so please select the response that applies to your current situation. I can just get that to launch properly. There we go. And the choices are, I'm a grantor, I've established a trust before. 2, I've been or am a trustee of a trust. 3, I am the beneficiary of a trust. 4, I'm considering establishing a trust. And 5, I'm an advisor here to learn to better serve my clients. So just take a few seconds to make the choice that best suits your situation and go ahead and get started. We'll take a few more seconds. We've got about 2/3 of people having cast their choice. Okay, so we have 20% saying I'm a grantor, I've established a trust before. 6% say I've been or am a trustee of a trust. Nobody says I'm the beneficiary of a trust. 53% say I'm considering establishing a trust. And 22% say I'm an advisor here to learn to better serve my clients. So thanks for participating. And then Steve, I'm going to go ahead and make you the presenter.
Thank you, Jeff. All right.
Okay.
And Jeff, I'll get to that desktop and play our presentation. Good morning, everyone. And thank you, Jeff, for that wonderful introduction and poll. That gives me an idea who's on the webinar today. Thank you for being here on a Friday morning. Your lives are very busy, and yet you're choosing to spend some time with us this morning. And I thank you so much for that. It's my privilege to be with you again and lead you through a discussion. And I thank my longtime friend and colleague, Jeff, for making this possible. Without him, I couldn't put on these webinars, and without all of the attorneys and staff here at Elville and Associates, we couldn't do what we do. So thank you for your support and for your time and attention. So along these lines, I want to give you some real substantive takeaways today, which is of course always our goal in these webinars. And as I was thinking about this, I thought about, well, you know, in this particular webinar, there is a lot of information about trusts themselves. So we're talking about trustee selection, but what I'm also trying to do here is give you some background for those of you who are not 100% having your minds around what trusts are. We're going to delve into that a little bit so that you have a framework from which to do what Jeff mentioned, have a jumping off point, which I thought was very well put. So we're going to talk not only about trustee selection and the issues surrounding trustee selection, but at times we're going to get into the weeds a little bit, so to speak, about trust. And I promise if you go into the weeds with me there, we are going to come out on the other side. So the other reason I'm always excited about this quarterly webinar that we do is because I always, maybe like yourselves, we like to be part of something that we can really provide some help to people. And this is one of the big subjects that I find in every day, every week here at Elville and Associates that clients are concerned about. They're concerned about how to get their minds around trustee selection. Who is the appropriate trustee? Who are the trustees that are available? What kinds of trustees are available? That's what we're dealing with here today. So thank you for being here. Again, I want you to look at this as get my pen and pencil out. I'm gonna get some notes down on paper or my tablet or my phone and walk away with something substantive that you can use as a jumping off point in your thought process. So we're going to talk about what a trustee is at a very basic level and what are their responsibilities. We're going to talk about the types of trustees and their characteristics. Now, of course, we only have so much time here, but we're going to talk about advantages and disadvantages at a very high level. And then, of course, we can always drill down further in person in a counseling session of some kind. We're going to talk about the perfect trustee. What would be the perfect person or organization to serve as a trustee in a conceptual sense? And we're going to talk about why this is so important. Each one of you have goals and you have intentions, and maybe you're being asked to serve as a trustee as a third party. There's all kinds of situations out there, but you're going to decide why this is important to you. But from a planning perspective, I'm going to provide that kind of information. We're going to talk about trustee succession and how plans should be designed. So you see, we're not only talking about trustees and the ins and outs of trustees, but the background behind the documents and the design and why this is so difficult and important. Then we're going to give some of you on this call, we're going to give you a background on the types of trustee roles. Trustees have roles in wills, trustees have roles in trusts, and those are similar but sometimes different. And then we're going to talk about why should you appoint a corporate trustee or an independent trustee that happens to be a corporation. And then we're also going to talk about the risks involved when you appoint trustees and the successor trustees and what happens in the future and all of those things that it's so hard to grasp when we're trying to think through these things. So let's talk about getting right into the matters here. What is a trustee and what are their responsibilities? Well, not surprisingly, some of this is common sense, but I'm not going to leave any stone unturned. I'm going to just assume that we really need to cover this fundamental information. The trustee's role is to administer the trust. And we're going to talk about the different kinds of trusts. There are living trusts, there are trusts at death, there are irrevocable trusts during life. There's all kinds of trusts, but whatever the trust is, the trustee is tasked with following its terms and provisions. Now, many of you might not be surprised, or maybe you will be, that many trustees don't fully read the trust. They take on a trust, but they haven't really fully read it and really understand it. And that may seem, so hard to believe, but it is true. And we want our trustee to administer the trust according to its terms and provisions. A trustee should keep accurate records. A trustee should account. And this is one of the things that if someone walks up to me and says, Steve, what is the trustee's real job? Well, their job is to be accountable, not just to pay bills and so forth, as in the next bullet point, make distributions, whether those distributions are mandatory distributions of income, so to speak, and for example, or discretionary distributions. But no matter what we do as far as paying bills and writing checks as trustees, we have to be accountable. Now, a trustee is a fiduciary, of course, and they are tasked with making investments. But should a trustee really be making their own investments? In my opinion, the answer is no, unless that trustee is also a financial advisor, a qualified person who knows how to make investments. They should be hiring professionals to make those investments, not doing it themselves. And I think that's common sense. But we do run into situations where individual trustees are not following those fiduciary guidelines. So that's a problem. It can be a problem. They need to communicate with the beneficiaries. So under Maryland law, beneficiaries have the right to information and other things that we're going to talk about today. But the trustee, they should communicate. And if they're not communicating, they're not keeping up with the beneficiary's needs, and they're breaching their fiduciary duty. Now, of course, trusts have tax compliance issues. So the trustee needs to file all tax returns and keep filings complete. And look at this last bullet point, manage the assets of the trust in consideration of the income taxation of trusts. So trusts have their own income tax rules and parameters, and the trustee needs to have a working knowledge of that. And they should not be completing their own tax returns, in my opinion, unless they are qualified to do so. But there are certain considerations that have to do with investments and the income produced by the trust and how that should be managed in terms of taxation. Now let's get into some basic review and definitions. What is a trust? So a trust is a relationship. So it springs from this agreement. And in the old days, a person who developed or implemented a trust, they were called a donor or a trustor, and there were other names, but now the modern term is grantor. So in his poll today, Jeff used the term grantor. Are you a grantor of a trust? And I know some of you on this webinar are grantors. So the grantor creates a trust, and then the trustee is the person charged with administering that trust according to the parameters and the role and responsibilities prescribed, the terms and provisions of the trust. So that hopefully makes sense. The trust has terms and provisions. We want the trustee to read the trust. We want the trustee to follow and be guided by the terms of the trust. I'm going to take just a second here to talk about something that might otherwise be missed. Not only does a grantor create the trust and provide the terms and provisions and guidelines of the trust, but it's important to know that a grantor could also provide a memorandum of intent. That memorandum of intent is an informal document that can be attached to the trust, whether it's a special needs trust or a general needs trust, and that also can provide very important guidance and personal direction to the trustee in a more informal way. So we talked about the grantor, which used to be called the settlor or trustor or donor. This is the person establishing the trust. And again, this is a really, really important definition of a trustee. The person who is accepting the property. The trustee not only agrees to serve, they agree to accept the property and manage the property along the lines of the terms and provisions of the trust. And a common sense definition, of course, of a beneficiary is the person who benefits from the trust. So the trust is intended to benefit someone either in a general way, so to speak, or for a discretionary type trust like a special needs trust. And the trust is going to prescribe how the property is to be distributed, when, and what are the terms and provisions for the benefit of the beneficiary. Now, many of you on this webinar have a revocable trust. And remember that a revocable trust is the very most common of all trusts. It is a trust that can be changed, it can be amended, it can be modified, it can even be revoked. Although most people don't intend or actually ever revoke their trust, it can be. And the income of the revocable trust is the income tax, I should say, is paid by the grantor. So the revocable trust is the most common of all grantor trusts. So we're going to be talking about that here in just a few slides. But a grantor trust is a trust where the grantor pays the income tax of the trust. Now, an irrevocable trust is a trust that I think the best way to think about this is it's a trust with a special purpose. Now, that's just one way that I like to describe this to clients. Think of an irrevocable trust during life as something like a gifting trust. Someone wants to make gifts into a trust. Someone wants to create a life insurance trust. That would be an irrevocable trust, or a charitable trust, or a special needs trust could be an irrevocable trust. And there are various types of lifetime trusts that can be created. So this is a trust that generally cannot be modified or revoked. Now, with that said, there are ways in today's world to modify irrevocable trusts through reformation or something called non-judicial settlement agreements, or through decanting and other methods. So we're living in a world where lots and lots of things are possible to change an otherwise irrevocable trust, and the grantors of trust have to be aware of this, and it's something that's very important to understand. Now, at death, we know that trusts become irrevocable. If we have a revocable trust, that trust will become irrevocable at our passing. So just giving you the parameters and the way to think about revocable versus irrevocable trusts at a very basic level. Now, what are common trusts? Now I mentioned some of them just a moment ago, so I'm going to be redundant here in an intentional way to keep driving this information home to you during this workshop. So traditional trusts include, something like I just mentioned, a revocable trust. So if you're a person who has only really been familiar with wills throughout your lifetime for various reasons, remember that a revocable trust is a substitute for a will. Don't be confused by, let's say, complexity here. There's nothing really to be afraid of as far as this definition. It is a substitute for a will. You can have a will-based plan, or you can have a trust-based plan, a revocable living trust. is a alternative to a will, a substitute for a will. Now, the main purpose of the revocable trust is to avoid probate and deal with out-of-state property, such as a Delaware residence, that's a second home, a Florida residence, or a South Carolina residence, wherever it may be. We can save probate here in Maryland and in that ancillary state. Or there may be concerns about privacy. There may be special concerns about the reason why we need to use a revocable trust is because of that special concern. But it does not save taxes. It does not provide for asset protection. So we need to understand that the revocable trust, again, is nothing more than a substitute for a will. Now, there are other trusts, such as irrevocable trusts that I just mentioned. These are trusts at death. Let's say someone passes away and you pass away and you leave a further trust for a beneficiary. This could be for their protection from creditors or from themselves or from a divorcing spouse or bankruptcy. These types of trusts are established for those kinds of individuals, or it could be a person with disabilities. It could be for a minor child. And of course, the trustee holds this property for the benefit of the person, and the property could be held in perpetuity. So some of you may have an idea that you would like the property that's left in a trust, or maybe that you are actually a trustee of a trust that is perpetual. This is a trust that is, we could call this several names. It could be called a lifetime trust for a child or another beneficiary. It could be called a bloodline trust, a trust that stays in the bloodline. It could be called a dynasty trust. It could be called a generation skipping trust. These are all names that are used for perpetual trusts. And these trusts are typically identified by having spendthrift provisions and other types of flexibility provisions, like a trust protector that can provide flexibility over a long period of time. Then we have beneficiary controlled trusts. So in the design of trusts, whether it's usually it's a trust at death, or it could be a trust during lifetime for a beneficiary, they could actually control the property in various ways. Maryland is one of the states that says that you can establish a trust for the benefit of someone, and they can actually be the trustee of their own trust. Now, the problem with that, as many of you have maybe heard me say before, is that there are many states that do not allow that. So Maryland allows for a beneficiary to kind of have the best of all worlds. They can have a trust, they can be the trustee of that trust, they can enjoy all the benefits of that trust, and including asset protection. But the problem is that we know that that's probably not the best arrangement in the world. A person could be sued under the laws of another state, and that state could be the kind of state that says they don't recognize trustees of their own trusts as being protected from the claims of creditors. And there are all kinds of other design issues. But the thing that I want you to take away from this particular bullet point is that when you're a trustee of a trust, you are either going to be the trustee where you are an interested person, you're a related person, or the trustee is going to be an independent person. And that independent person is always going to give the beneficiary greater asset protection than if there was a situation where there was an interested person. Now, remember, there are exception creditors to trusts. So trusts protect, for example, a spendthrift protected trust that's properly designed is going to protect against most creditors, and of course, divorcing spouses and so forth. But there are exception creditors. Uncle Sam, the IRS, is an exception creditor. The child support obligation type issue and alimony issues, those are exception creditors. There's only one state that I'm aware of where there are no exception creditors, and that is in Nevada. So let's go to the next bullet point now. There are special needs trusts. You've heard me mention this a few times. And here at Elville & Associates, we're very blessed to be heavily involved with the special needs community and helping families with special needs trusts. So there are really two types of these trusts, just to give you this background information. There is what is called a third-party trust, This is the most common special needs trust. This is the bread and butter of estate planning for families that have a loved one with special needs. And then there is the self-settled first party trust, we call it. And this is the one that holds the assets of the individual, where the disabled person themselves has received assets that they really shouldn't have in their own name. So the third party trust, or what is called the third party supplemental needs trust, that is the one we most deal with. And of course, the purpose of these special needs trusts is to hold the assets of the individual for their benefit, creating another world of support for this person other than the world of public benefits. And then this world of support is there either strictly for their supplemental needs only, or in the discretionary words of the trustee, meaning in the discretion of the trustee, so that the trustee can decide whether public benefits should override private distributions for the benefit of the individual. All right, so let's again go back to the basics before we move on. A trustee is a person who accepts the trust property and manages and distributes the property. Okay, now there are two types of distributions from a trust. There are distributions directly to the beneficiary, and that's pretty commonsensical. And then there are beneficiaries for the benefit of the beneficiary. So a trustee makes distributions either to or for the benefit of the beneficiary. And of course, the beneficiary is the person for whom the trust is intended to benefit, and the trust terms and provisions dictate how, when, and for what purpose the trust property is to be used. Okay, Jeff, we've been going for about 20 to 25 minutes, and I just want to stop and see if there's any questions, and then we will forge ahead. Just wanted to make sure.
Thanks, Steve. Yes, let's answer a few questions. The first one is, can you confirm that this is relevant for my circumstance? I am the legal, I think it should say, guardian for my son with special needs.
Yes, I don't fully understand your question, but I think I can extrapolate off of what you've said. This presentation, if you're asking, is relevant if you are the guardian of your special needs child, because my assumption would be that if you're guardian of your special needs child, then your special needs child probably does not have the mental capacity to appreciate the nature of their own decisions and needs protection, and they are probably vulnerable in some way. So in your own estate planning, the vulnerability of your child would be taken into consideration through your own will or trust that would provide for a special needs trust for your child at your death. So when you are developing your own estate plan to provide for the protection of your child or others, then what you're going to be doing is thinking through these issues about who is my trustee, because after you are no longer here, you are going to require, in most cases, a trust. It sounds like in your case, a trustee that would be there to help take care of your child and provide for their benefit as trustee of the supplemental needs trust.
Okay, thank you. Next question, are you or someone in your organization able to serve as a trustee or as personal representative? And a follow-up question from the same person, what are the statutory fees for trustee and for personal representative?
Thank you for those excellent questions. So the answer to the first one is yes, we are very privileged to serve in many cases as personal representative of an estate. So we are available to do that, and many attorneys, including us, do serve in that role. We are also trustees of certain trusts, and we have a trust division. We call that our Waypoint Fiduciary Services, LLC, and we serve as trustee. And this is a situation where we are trying to be there for our clients and the public at large by filling a vacuum, I should say, or filling a gap that exists between those folks that want an independent trustee, but they don't have enough money many times to meet the minimum requirements of corporate trustees, such as banks or other financial institutions that are corporate. So sometimes we have trusts that are larger, sometimes we have trusts that are smaller, but thank you for asking that. That is called our Waypoint Fiduciary Services, LLC. And the second phase of your question, I think, had to do with fees. So in the realm of estates and that are administered under the Register of Wills and the probate laws of Maryland, the statutory fees are as follows, if you're writing this down. The statutory fees are $1,800, that's $1,800 of the first $20,000. So the first $20,000 in probate is $1,800 is the fee that's allowed. And for assets over $20,000, it's 3.6%. 3.6%. So I would think in terms of about 4% of the probate assets are the statutorily allowed fees in probate. Now, fees in trust administration vary. There are independent trustees, and they are required to submit a fee schedule with the Department of Financial Regulation. So that's where the fee schedules would be for independent trustees. And also, there are many trusts that are drafted that say that a reasonable compensation is the standard of trustee compensation. And what is reasonable for one person might be not reasonable for another. For example, a non-professional trustee, reasonable compensation where there is no fee schedule filed might be $50 an hour, whereas a professional trustee would justify hourly rates of much higher than that. And then lastly, there is such a thing as statutory compensation. So many older trusts or testamentary trusts either do not mention compensation, or they do say that the compensation should be statutory. So the statutory compensation is quite conservative. And for that reason, many modern trusts are drafted where it does not say there will be statutory compensation out of fear that no one would be willing to serve. So reasonable compensation is the modern standard, but I would go one step further and say where there are independent or corporate trustees that are regularly administering trusts, they should file a fee schedule with the Office of Financial Regulation.
Okay, well, thank you for that very good answer, detailed answer. Next question from our financial advisor friend Kelly. He says, I think Virginia has decanting, but does Maryland allow for decanting yet?
Hi, Kelly. Thank you for that question. Hope all is well. Well, the answer is no. I think there is a decanting bill before the Maryland legislature right now, and I'd have to double check on that. I did see a draft copy of the bill, and my assumption is that it has been actually submitted for review in the legislature. So I think it's coming for sure. And you're right, Kelly. Virginia has very liberal and very eye-popping modern decanting laws, just as does our neighbors to the east in Delaware. But Maryland, it does not have it yet. I predict they will either have it this legislative session or next.
Okay, thank you. Can we do one more?
Yes.
Okay, great. What is the minimum value of an effective grantor trust? At what level of dollar value is a trust needed?
That is a wonderful question. Thank you for that. And of course, not knowing the situation and that you may be referring to, I can't give legal advice on that. But I think I understand where you're going with that question. All trusts are really a question of, is it economically viable? Is it economically feasible to leave a certain amount of money in trust? Now, grantor trusts, you specifically asked for that about that. Grantor trusts are trusts that are deemed to be advantageous because they're being developed so that the grantor can pay the income tax. And in many cases, this is just the best thing to do, the highest and best thing to do. And Uncle Sam at the world of trust and estates is very happy that Uncle Sam has not taken away the benefits of a grantor trust, which provide for so much flexibility in planning. So my assumption is that you're referring to more advanced grantor trusts, and this is going to be a case-by-case thing, I hate to say, because it depends on whether it's a life insurance trust and whether there's going to be a lot of money gifted to the trust, whether it is some kind of a sale transaction where we are using a grantor type trust, whether it is a gifting trust. So it just depends on what the use is going to be. And I think in each situation, there would be kind of a common sense point where the administration of that trust and the costs of it would not be worth it. So I apologize that I can't be more specific than that, but that's a wonderful question.
Okay, thank you, Steve.
Okay, so we're going to thank you for those wonderful questions and your interest. Let's get back now to that very issue that was just described, which is the grantor trust versus a non-grantor trust. So I will give you very quick examples of this. So the revocable trust, remember, is a grantor trust. Don't get confused by this issue. It's so confusing to so many people. I want you to just think about this, that a grantor trust is a trust where the grantor, not the trust itself, the grantor pays the income tax. So as mentioned just a moment ago, a revocable trust is the simplest form of a grantor trust. The grantor pays the income tax. A life insurance trust is generally drafted as a grantor trust. Now that's an irrevocable trust, not a revocable trust, and yet it is deemed to be a grantor trust if it's drafted properly in that way, and the grantor pays the income tax. A non-grantor trust, and I'll give you the simplest example of this, would be when the person passes away with a will or a trust, and they leave a further trust for a child, grandchild, or niece or nephew. That further trust is a trust at death. That trust is irrevocable. That is a non-grantor trust. That is the most common kind of non-grantor trust, in my opinion. And that's the kind of trust that many of you are on this webinar to learn how to administer. That non-grantor trust pays its own income tax. It has its own special nuances that we talked about in a few slides ago earlier in those bullet points about making sure the trustee understands how to administer a trust and how to deal with the investments in the trust and how to deal with the income taxation of the non-grantor trust, which has to file, in an ideal world, has to file a 1041, that trust and estate tax return, and that 1041 is going to show how much income that trust has, and that income is going to be subject to high income tax rates at a very low threshold to get to the 37% bracket, unless the income is distributed out to the beneficiaries. So non-grantor trusts, those are the trusts, I'm just using a simple example, the trusts at death, and then the grantor trust is the trust where the grantor pays the tax, not the trust. Now, for those of you who are administering trusts, or as you think in terms of who your trustees are going to be, remember that trustees have responsibilities under the Maryland Trust Act. So the Maryland Trust Act, so long ago now in 2014, was very, very big. And it says, you know, for the first time in Maryland law, beneficiaries are entitled to notice, and beneficiaries are entitled to information. So if you are the trustee of a trust and that trust is irrevocable, now we have notice requirements. And remember, you are held to a fiduciary standard. So you must provide the required notices and the required information if a beneficiary asks for information, and you must provide that or you will be in breach of your fiduciary responsibility and you could be removed. So it's hard to believe that prior to 2014, beneficiaries of a revocable trust or that becomes irrevocable or another irrevocable trust had no rights to information basically or to notice. But now that has all changed, and this was a very, very big change in Maryland. And remember that, as I mentioned, the qualified beneficiaries, for better or worse, they have the right to information, including a copy of the trust, annual reports, and so forth. And in my opinion, and opinions could vary on this, beneficiaries have the right to all information, And there is no such thing in Maryland as a quiet trust. There is no such thing as a quiet trust. In some of our neighboring states, there can be a quiet trust, but not in Maryland. Now, as we're dealing with a trust, we know that we want to hire professionals. We don't want to try to go it alone. We don't want to be exposed to the liability that would come from doing things that we really have no expertise in doing. So a good trustee is going to rely on a financial advisor, and that financial advisor will understand, if they're the right one, they're going to understand that you as the trustee, or that your trustee that you're choosing, has a fiduciary responsibility. Now, if I'm a trustee of a trust and I am not a professional financial advisor, and I'm hiring a financial advisory firm to manage the trust assets, what do I want to get for myself? I want to have an investment policy statement. I want that financial advisor to understand that I'm a fiduciary. I have a responsibility to follow the terms and conditions of the trust and to act in the highest and best interest of the beneficiary. And that financial advisory firm is going to provide me with that investment policy statement that I can put in my file, and I can show that I am acting as a fiduciary, and so is the financial advisory firm. So getting back to some fundamentals here, the financial advisor is going to, of course, help open an account in the name of the trust. Let's start right here and drill down into something very basic. Let's take a very simple example of a revocable living trust. That trust is a living trust during the person's lifetime. But what confuses so many people, and you won't be confused now by this at all, is that at the death of the grantor or the grantor spouse, if they're married, this trust or trusts become irrevocable and they have to be administered. They have to be administered, they have to have a tax ID number, and the new accounts need to be opened, especially after the time of distribution. So we have the trust, we have the date of death, we have administration of that trust, which confuses many people. Then we have a final accounting, and then we have distribution. And when distribution occurs, our financial advisors will help open up new accounts in the name of trusts that are going to continue in this example, and statements that need to be sent out, and checkbooks, and having money market account funds available to make distributions, and all kinds of allocations that need to be made, and the things that our financial advisor friends do very well to take care of us. As trustees, we want to understand that we have the ability to hire professionals, and those professionals are going to take care of us as we take care of the beneficiary. And they're going to assist these these financial advisors are going to assist us with stepping up the basis on assets that are now getting ready to be distributed, so there's no capital gains in many cases, and distributing assets by either selling them and helping us distribute them into further trust, or moving assets in kind without selling them, which sometimes is the right thing to do. And of course, the trust is going to be managed. It has to be managed. And a good trustee, as you think about who your trustees are going to be, a good trustee is going to rely on the financial advisory team. They are acting as trustee. The financial advisor is advising. The CPA is advising about the best and highest administration of the trust and the growth of the portfolio and how it should be administered. There is someone on this call that I happen to know is on this call, and that person is very aware of a situation we encountered where a trustee was managing a trust for years for several different people, separate trusts. These were testamentary trusts at death that were being managed by a trustee. That person did not have the trust investment portfolio allocation correct. They had an allocation of assets that were contrary to the provisions of the trust. So this is something that can happen, and this person was supposed to be a professional, and they had this backwards, and they did not have the interests of the beneficiaries in mind. So again, this is where the financial advisor can look at a portfolio if you're inheriting a portfolio as a trustee, and really make changes and say, this is not appropriate. This is not really in accordance with the provisions of the trust. So we need to understand the needs of the beneficiary. We need to keep a certain amount of cash available, and we need to take care of that person, whether it's monthly distributions, in the case of a special needs trust, using a TrueLink card. A TrueLink card is a way to control distributions to the beneficiary and to know when to make outright distributions versus distributions for the benefit of the person. Now, I keep telling Jeff, and one of these days we're going to actually put some of these photos that I talk about up here. These concentric circles, in my opinion, really personify what a trustee should do. The perfect trustee. Who is that person? And I always tease Jeff that someday we're going to find some photos of the perfect trustee. We're going to put them up here, and we're going to have a little bit of a laugh about these individuals. But of course, there is no such thing as the perfect trustee, but this is the standard by which we want to measure. The trustee needs to be accountable. Let's go down here on the left. Of course, they want to keep accurate records. They want to keep the beneficiaries informed and comply with those Maryland Trust Act statutory duties and the fiduciary duties. And you know, as we go across to the financial obligations, we want to have the proper investments done, not by the trustee unless they're a professional investment advisor, but through understanding that they have to rely on professionals, understanding taxes at a very fundamental level, but relying on the CPA, hiring professionals and not going it alone, having an investment policy statement. And then, of course, depending on the situation, be an advocate for the beneficiary. Some beneficiaries are going to need more advocacy than others. Some are not going to require any maintenance, but understanding public benefits if the person is at risk or has disabilities, promoting the independence of the person. I'm dealing with a trust right now where the beneficiary is really struggling with what to do with their life. And they need advice, they need counseling. And I think a good trustee tries to provide that as much as possible. And many of the professionals here on this webinar do that. And we want to be advocates in the best interest of the person and help them along in their life. So these concentric circles represent the ideal thing for trustees, the ideal standard. Now let's talk about why trustee selection is so important. As I mentioned at the outset, each one of you has your own goals and purposes in either thinking about trustee selection or being a trustee or as a financial advisor or other professional, understanding what people are really thinking about this subject. But it's important because, as I mentioned earlier, trusts can now last forever. In Maryland, Maryland has no rule against perpetuities. And that just means that trust can just last forever until there's no more money left. And that Maryland law is actually more progressive than our friends in Delaware. They also have no rule against perpetuities, but not for all property. Nevada has a rule against perpetuities that is shorter than Maryland's, believe it or not. So even these liberal trust states that have asset protection features that Maryland does not have, they are not quite as liberal as Maryland in our no rule against perpetuities, and trusts can last forever. Trusts are more portable than ever. One of our financial advisory friends on this call mentioned Virginia, mentioned Delaware. I mentioned Delaware, and now I've mentioned Nevada or other places that a beneficiary could live, or places where trusts have more advantages than in Maryland, perhaps. Not always, but perhaps. So trusts are portable. Trusts can be changed. The situs and location of a trust can be changed from Maryland or any other state, depending on the situation, to another state. States are in competition for trusts. This past week, I was on, speaking of Nevada, I was on a call with a very prominent Nevada attorney about the advantages of Nevada law for one of our clients. So states are in competition. Nevada arguably says it's the best asset protection state. Delaware argues that it is. South Dakota argues that it is because it has more assets than all of the other states combined in asset protection trusts. And of course, there are states like Alaska, and now there are many asset protection jurisdictions, I think up to 19 of these. But just understand that states are in competition for trusts, and that's why trustee selection is so important, that the world of trusts and estates is much more fluid than it has ever been. Beneficiaries are likely to change their domicile. So our children, our grandchildren, our nieces and nephews, whoever these beneficiaries are going to be, they, as many of you know, can live anywhere. I was at a conference recently in Portland, Oregon, where someone said, you know, Steve, I live in New Jersey. I work for a company. I'm never home. I'm going to stay in New Jersey maybe a couple of months a year, but I'm going down to Palm Springs, California for 3 months. And then when I'm done there, I'm going to go to Florida for several months. And I just work from wherever I am. So that's more of an extreme example, but it illustrates that beneficiaries are likely to live anywhere these days. And we don't know where our beneficiaries are going to be at our time of death, where the trusts for their benefit are going to be sitused. Now, Maryland documents are going to be, of course, sitused in Maryland. The trust is going to be taxed in Maryland, but remember that may change. So we have to be aware that trustee selection needs to kind of take into consideration the possibility that our loved ones are not necessarily going to be in Maryland. Trustees have options. They don't have to serve. Now, this is a little bit of a negative thing that I'm bringing up, but it's so true. We need to be aware as we're thinking through trustee selection that our trustees are ideal, the ones that we decide on and conclude should be our trustees, but they are not necessarily going to be around forever. They could resign because they were not well, or their life circumstances had changed, or they simply could resign from the get-go, unfortunately, when the time comes for them to serve. So we want to get to the bottom bullet point here in just a second and talk about flexibility, because this is a very scary prospect to many people, that the fact that a trustee does not necessarily have to serve. I'll get there in just a second. Decanting, I mentioned this. Decanting is the strongest power in estate planning by far. Kelly asked whether Maryland has decanting yet, and it doesn't quite have it yet, but I think it definitely will. And decanting is the ability to actually change a trust from one form of the trust to another trust. Now, this is very scary. And in some states, the decanting laws are much more aggressive and much more liberal than in others. I anticipate that the Maryland decanting statute will be much more conservative than liberal, but that remains to be seen when it happens. So all of these things are out there in the world. The elements of what is going on in the estate planning world and the constantly changing political environment and tax environment. So we want to infuse, is maybe the best word, flexibility into the trust. In the situation I was describing earlier, where the trustee was not acting in the best interest of the beneficiaries and had an improper allocation of assets for the beneficiaries for many, many years, and they had no control, the reason for that is there was no flexibility built into that plan. And largely that was because it was an older plan from years and years ago under an old will. But where grantors of trusts have, and people who develop wills that actually have trusts that emanate from the will, those individuals who are creating wills and trusts today, they really strongly should consider building flexibility into the plan for changing circumstances. And with the world that we are living in today and so much happening, I don't think I need to describe that anymore. Trustees, however, getting back to that bullet point, trustees can refuse to serve. Many of you on this webinar have seen this happen, but if you haven't, I'll explain this to you. I have actually worked with clients who implement trustees, and some of these could be corporate trustees, some of these could be individual trustees, non-independent persons, and those trustees at the time of that they are needed, those trustees can refuse to serve and have refused to serve. Some trustees will refuse to serve because of changed circumstances. Some trustees, such as corporate fiduciaries, might refuse to serve if they don't like the portfolio at the time of death, or they think that it's just not in their best interest to serve. So as grantors of trust and people that are implementing wills, we have to understand that flexibility is incredibly important in today's world for most plans. Now, the trustee selection process could be very easy for someone. Maybe they have a mental checklist. I know my child is going to be our trustee, or our 3 children in the order listed are going to be our trustees, or my sibling, my brother who is 10 years younger than me, he's going to be my go-to person. So some of this could be very easy. But let's talk a little bit more now about interested versus independent trustees, because remember, our children or our siblings and other relatives, these are people close to us. They're usually non-professional trustees, and there may be a reason to consider independent trustees versus an interested type trustee. Now, the first thing to know about independent trustees is where we have an independent trustee for beneficiaries, their asset protection, meaning the asset or creditor protection against a bad spouse, car accidents, bankruptcy, all of those issues, the asset protection is very generally going to be much higher. So when we have independent trustees, the protection for the beneficiary is, again, much higher in a general sense, versus where someone is the trustee of their own trust or an interested family member in accordance with the IRS rules, which are beyond the scope of this discussion. Now we have a modicum, as we would say, a modicum of asset protection, but not the kind of asset protection we would really like under all circumstances. So asset protection is an issue with regard to interested trustees versus independent trustees, and a goodwill or trust will recognize this and provide for flexibility depending on what kind of trustee is serving, okay? Now, another consideration here is some people, they don't want to burden others, individuals or family members with the trustee duties or responsibilities, and this is going to vary greatly between clients. So independent trustees, whether they are individuals or whether they are corporate trustees, could be very attractive. So what I recommend to all potential clients or clients is that if you're considering an independent trustee, to interview, of course, that trustee, make sure what is the game plan, what is the team, what are their methods and mechanics, how do they get paid, but more importantly, how do they take care of the beneficiaries? What is going to happen after your passing or the grantor's passing? And what are the resources they have? And these are very important discussions. But remember, what maybe is even more important is to have a trustee succession, and we're going to talk about that here in a few minutes, and flexibility built into the plan. Another reason someone might consider an independent or corporate trustee is because, for example, the corporate trustee will normally have, almost always have their fee schedule filed with the Secretary of State and the Department of Financial Regulation, but they also usually do and provide the trust tax return, and they also are making the investments. So this varies now depending on the financial advisory firm and whether they have an affiliated trust company relationship, I should say, as many of those companies do. And then, of course, there are many trust companies outside the state of Maryland. Not so many trust companies in Maryland, but certainly many trust companies outside of Maryland. So interested trustees versus independent trustees, there's many different aspects of this. This is something that you must think through in a counseling type environment to understand and learn about this better. And as I mentioned here, we go to the next bullet point. This is best done in a review session where there's lots of issues that can be visualized and discussed and illustrated and charted out. And of course, there could be conflicts between interested trustees. So this goes without saying that there can be, in many circumstances, very bad situation where one interested person is put in charge of another person's trust and their distribution. So all this to say that there are many advantages and disadvantages of both sides of the coin here. And good trustee selection is a result of counseling, but also building in flexibility. So let's talk about the trust protector. The trust protector is a special fiduciary. Maryland law actually calls this a trust advisor. Nationally, this is known as a trust protector. And basically, to make a long story short, a trust protector, if you're not familiar with this, is a special fiduciary who has two major powers. However, they can have more than these powers. The major first power is the power to remove and replace remove and replace trustees, not beneficiaries. And the trust protector has the authority to remove and replace trustees. And this could be for purposes of being able to switch out interested versus independent trustees, or just to provide that the grantor's intentions are being carried out. And if a trustee needs to be removed, they can be removed. Now, let's talk about that trustee that refuses to serve. The trustee who refuses to serve, now you see that we instantly need the services or the benefits of a trust protector, because the trust protector will now be able to appoint a trustee if one is needed. Let's say that a corporate or independent trustee was appointed and then they refuse to serve for no apparent reason. And I have actually seen that happen, and that's kind of scary. The trust protector steps in and now another trustee can be appointed. Now, if no trust protector is appointed, there can be methods used, such as going to court to get another trustee appointed. But if we want to keep things in continuity and we want to keep things private and we want to provide that flexibility, we want to include a trust protector. The second duty of a trust protector is they have the ability to amend the trust administratively. So a trust may need to be amended, but if it does need administrative amendment for changes in the laws, or the tax laws have changed, such as the recent changes to the Secure Act and the regulations, the trust protector has the power to administratively change a trust. So the trust protector can be given many powers, and when we build trust protector continuity into a trust, it can infuse many different aspects of the trust and provide just wonderful flexibility. Some people are squeamish, and understandably so, about the concept of a trust protector, that a third party, an independent person, is what a trust protector is supposed to be. There are exceptions to that rule, but a trust protector is supposed to be an independent, arm's length person. So there are people who they're reticent about this issue. And so it takes a little bit of getting used to. I would recommend that you also consider that not only a trust protector could be installed, but there could be a special fiduciary appointed to remove a trust protector if the trust protector needed to be removed, and it makes sense to the grantor and gives them peace of mind that not only are they appointing a trust protector, but appointing someone who could remove a trust protector. Now, we talked a little bit, I got ahead of myself there just a little bit, about interested versus independent trustees. And of course, we've got different standards of distribution. Interested trustees are held to a different standard than independent trustees could be through the proper design. This goes to the issue of asset protection. There are different points of view of objectivity and oversight. There are different practical considerations, which we briefly mentioned, which I won't go through again, about the on-the-ground circumstances of taking care of and providing for a beneficiary. I was just meeting with clients yesterday whose child is in another part of the United States. And the issue is, how do we choose a trustee that will provide for that person, where they are and their geographic area versus where we are? So practical considerations, flexibility, counseling. I hope you're getting the gist of this as you are trying to get to a jumping off point of being able to understand what to do next. As I mentioned, the trust protector is a special fiduciary. Trust protectors have been around, in my opinion, for about 25 years. And the trust protector did not become a reality in Maryland in the law until 2014. Elville and Associates was using, and many other advanced estate planning firms were using trust protectors in their documents before 2014, but now we have it officially. And again, I want you to think about the role of the trust protector as mainly a power of amendment. I want you to think about it as a power to direct the trustee. And this is very scary to some people, But if you're a professional on this webinar, I think you'll find that most people, most clients will accept this as a good idea, that this is something that provides that peace of mind and flexibility, especially for longer term trusts. So if we have those lifetime trusts, those perpetuity trusts, so to speak, we definitely want to use a trust protector, except if it's just very uncomfortable for the client, and that does not happen in most cases. So it's basically a power of amendment, the power to remove and replace trustees, the power to direct the trustee in certain areas that are provided for by the grantor. But all the other powers could be included, and there are many, many other powers. I'm just giving you a couple here. The power to mediate disputes, if there are disputes that arise between the beneficiary and the trustee, that definitely does happen. The power to compel an accounting. What did I say at the beginning of this presentation? A trustee's duty is to what? Account. So if a trustee is not accounting, a trust protector could compel that trustee to account, and of course would have the power to remove a trustee that is not accounting. Now, as we think about wills, and we're going to start towards the wrap up of our discussion here today, wills can have trusts, and let's start with spousal trusts. So if someone is married and passes away, they can leave outright assets, correct? But they also could leave assets in further trusts. So we could see a bypass trust or a marital trust. A better way of saying this is we could have a marital trust, assets that are kind of flowing in the direction of the surviving spouse, or we could have a non-marital trust, and there's all kinds of names for those trusts. The credit shelter trust, the family trust, the residuary trust, and so on and on. These trusts have various names, but these are trusts for spouses at the passing of one person. Trusts for young beneficiaries under a will, where a person also could be their own trustee. So this is this testamentary trust. Someone dies with a will, there is a trust established after the probate process. That's a testamentary trust. That's an irrevocable trust, and that is a non-grantor trust, if you remember, where the trust will pay its own tax. It has to be managed, and there also could be a trustee established for a trust other than for that person, him or herself. So these are the types of trusts that are established under a will, and in addition to many others that could be established. Then in a revocable living trust, which remember is what? It is a substitute for a will. It's an ancillary, a non-probate device, okay? And this living trust, okay, it actually exists during life. So many of you on this webinar have a living trust. And if you have not thought about this in some time, remember that your revocable trust is not just a death instrument. It is a living trust. So that trust provides for your care if you are incapacitated. So if you are incapacitated during life, a role of your trustee is to step into your shoes during your life. Now, 99% of the time, that person is going to be the same person who is the power of attorney under the as an attorney, in fact, under the power of attorney. So we have someone who is stepping into your shoes or the shoes of the grantor as the trustee of the revocable trust. They are also stepping into the shoes of the grantor for their non-trust assets as the attorney, in fact, the agent under the power of attorney. So a role of a trustee in a revocable trust is to step into the grantor's shoes if they are incapacitated. And what do? Pay bills, take care of the grantor, take care of the grantor's spouse, take care of anyone who is dependent on the grantor. And then, of course, the second bullet point, we have the same types of trusts that are established that could be established under a will. But these trusts are established under a revocable trust. If the assets are not going outright to the survivor, then they are all going to go to a non-marital trust or a marital trust. And now we have to have a trustee for those trusts. And just like a will, there are trusts for young beneficiaries. There are trusts for third parties. There are trusts created at death. These are irrevocable trusts for those third parties or interested persons like children. And these are irrevocable spendthrift trusts And those are the non-grantor trusts I just spoke about that are established under wills. So these trusts are created under a revocable trust, and these are either for spouses or non-spouses, just like in a will situation. Getting back to the corporate trustee idea as we start to wrap up, someone might consider a corporate trustee for their experience, their asset management capabilities and the tools that are available to them, the fact that they are regulated by state and federal governments, and I mentioned Maryland's regulations, that they are reliable in the perceived and the perception of the grantor. These are reliable people, or they will have a successor. And remember that you could have peace of mind by appointing a corporation like this if you are so inclined, but you can even have more peace of mind if the person that appoints the corporate fiduciary also appoints a trust protector. And they have the peace of mind and the knowledge to know that if that corporate relationship is not working out, the trust protector can make changes. The objectivity of the corporate trustee could be considered better than those of an interested person that's closer to the situation. Again, the longevity and the tools I mentioned tools and resources, that this corporate fiduciary is a hub of information. They have the resources available to assist in various circumstances. All of these, subject to interviewing and researching and counseling, all of these could be advantages of a corporate fiduciary. With all that said, why should we be concerned about successor trustee risk? Well, I already mentioned some of this. I mentioned that I have, in my experience, seen clients rely on certain trustees, plan for the use of certain trustees, get the assurance of certain trustees, many times right in my presence. And then at that person's passing, the trustee does not serve. The trustee refuses to serve for whatever reason. So there is successor trustee risk. That's why we need to build in flexibility. But let's talk about other elements of trustee risk. The age and experience of your non-corporate trustee. That's a risk, right? Everyone's getting older. Everyone could have health issues. And that's getting to the second bullet point, that could deteriorate over time. Now, before we get too worried about this, I just want to stop for a second and say, I'm sitting here in conference room number 1 at Elville and Associates, and it's a beautiful day outside. And I'm looking to my right and I see my conference room chair at the far right end of the table. And I always have a good memory that about 8 months ago, I had a man that was 105 years old sitting in that chair talking to me about his estate planning with his wife. And this just illustrates to me just how long people are living today. Not everybody lives to that age, but the idea here is that just because your fiduciary, someone that is being chosen as your trustee or someone you're considering as trustee, just because they are your age or because they're over the age of 70, for example, does not mean that they cannot serve. So I just want to make that clear. Yes, people have health issues. That's a risk. We want to make sure that we have many successor trustees in the order listed, including potentially corporate trustees, to really account for this issue of the potential deterioration over time of our trustees' health, of our trustees' availability. But always keep in mind that people are living longer, and just because your fiduciary is older does not mean they are a bad choice. Remember, most trusts do not require bonds. So remember, a bond is an instrument that protects the trust assets. Most trusts say, I waive bond, but just remember that this is a successor trustee risk. When a trust waives bond, which very much, most all of the time, it's a good idea to waive bond because bonds are very expensive, not to mention that they are difficult to get, and they can diminish the principle of the trust. But remember that trusts do not require bonds most of the time, and that is a potential risk that we have to consider. Life changes for the trustees. Divorce, these are individual trustees. Divorce, creditors, bankruptcy, unforeseen things. All of this indicates we have to build flexibility into modern trusts. What if the trustee had a disconnect with the needs of the beneficiary? What if the trustee ignored the needs of the beneficiary, did not make proper distributions, refused to make distributions? These are risks, and we need to have a mechanism to deal with that. The demands of the beneficiary can be a risk. So let me explain what I mean here as we really start to wrap up, I promise. Many beneficiaries can be demanding. They can be so demanding and they can be so out of control, so to speak, that the trustee refuses to serve, or that they literally can force a dissolution of the trust. So we have to remember that there is risk in the type of beneficiary that the trust is provided for. And part of the selection process is to take into consideration, is this trustee up to the task? And will they be the strong trustee that we need? And that gets to my next bullet point: willingness, fortitude, and perseverance. And then there's successor trustee risk in compensation, which I know is a very touchy subject. Trustees need to be held accountable for their fees. Trustees can, at times, exact lots of money from a trust. So this needs to have oversight. This is another reason for special fiduciaries like a trust protector. But on the flip side of this, let's say we have a perfect trustee. This person is wonderful. They serve with dignity and honor. They carry out their duties perfectly. We want to make sure that the trust adequately compensates that person so that there is not this risk of them refusing to serve, thus creating more risk for the trust. So as I wrap up and turn this back over to Jeff, I thank you for your time and attention. I'm hoping that you've taken away several points, but at least something of substance from this that you can use, as Jeff said, as a jumping off point. We encourage you to have a path forward. Counseling is the key. Discussion of particular situations and the facts and circumstances of each situation is a key. I've sat on many calls with clients, talking to potential trustees and really trying to ask all the right questions, or helping the client to ask the right questions so that we can really get our minds around the right choices. The client can get their minds around the right choices. So we encourage you to set a consultation and have this discussion. If there are questions about existing estate plans, we generally do not charge to review existing documents. We encourage you to understand that there's nothing to fear. When you consult with an attorney on this and these kinds of matters, there is an attorney-client relationship that is created. Whether you actually become a further client or not, that information is protected. It is attorney-client privilege. So we review documents. We love to help you form an advisory team of a CPA, a financial advisor, if you don't already have one, and to help in some circumstances with insurance professionals or life care managers in the case of elder law situations. And we want you to bring questions. And if you have questions, bring those questions, bring your list of questions. We love those. And we want to give you the time to think, the time to step away from what is happening in the world and really be able to move forward with purpose and with goals of accomplishing what you want with regard to trustee selection. And that could include the Waypoint Fiduciary Services LLC that we have here at Elville and Associates. We are proud to serve if we can help and plug a gap or fill a vacuum where it needs to be filled and provide peace of mind. But there are many, many choices, and that is part of the counseling process. So we want to help you have that place to be able to move forward. Jeff, I'm going to turn it back to you on this beautiful day. We're 10 minutes early. And again, I thank everyone for attending today.
Well, thank you, Steve. It is a beautiful day out there, and a really thorough and thought-provoking presentation. And thank you for leading that. Just several questions that have come about from that presentation. So let's go ahead and dive in here. Then we'll have just a couple closing thoughts. So first question, in a third-party special needs trust, the money in the trust can be distributed by the trustee to bolster the amount provided through Medicaid? Actually, that should be a question, I guess. Can the money in the trust be distributed by the trustee to bolster the amount provided through Medicaid? For example, if you want to pay for more services than are provided or better quality of services.
That's a wonderful question. Thank you. And the answer is absolutely, you're right about that. What we have to be concerned about there is the trustee's knowledge of public benefits, and specifically the trustee's knowledge of the public benefits that the person that's the beneficiary could be and is receiving, and making sure they understand if those are means tested benefits, which many times they are. Distributions absolutely can be used for the benefit of the person, distributed for the benefit of the person, but they have to be done in a certain way so as to not disturb that person's public benefits. And there are techniques that can be used to do that, such as the use of the TrueLink card. But let's say that assets are actually not going to be distributed for the person to actually use themselves, either on that TrueLink card, for example. Then assets should be, funds should be distributed for the benefit of the person. And a simple example would be the trustee typically would not give the beneficiary on public benefits $600 to buy a new iPad. The trustee would simply buy the iPad, and that would be the distribution for the benefit of the person, and that will keep that situation from ever becoming a situation where the person's benefits would be affected.
Okay. Next question, is a testamentary trust the same as a discretionary trust?
Thank you for that question. A testamentary trust could be a discretionary trust. A good example would be from your question, let's say someone has a will-based plan and that person says, at my death, I am establishing a discretionary special needs trust, supplemental needs trust, so to speak, for the beneficiary. That trust is both a discretionary trust and a special needs trust as a testamentary trust. Now, remember, a special needs trust could be, or another trust could be established during lifetime and not at death. But your particular question is, the answer is yes, it could be both.
Okay. Next question, do you or your firm help set up CRTs?
Thank you. Just for everyone's knowledge, the charitable remainder trust is what the questioner is asking about, and the answer is yes. So thank you for that question. We do set those up, and those are very, very nice tools for people like you who are charitably inclined.
Okay. What is the typical minimum for establishing a trust and having a corporate trustee at a financial institution?
That's another wonderful question. Now, this is going to depend on the institution, and I have heard things recently as minimums as high as 5 million for a very well-known bank in this area. I happen to know other banks in this area, if we're just talking about banks and their trust services, somewhere between 1 and 2 million. But certainly I would say for most corporate trustees, independent type corporate trustees, it's going to be a minimum of probably 500,000 to $1 million, and most of the time $1 million and upwards. But it's all going to depend on the institution and their policies.
Okay. Next question here, a bit specific. Maybe you can provide some guidance here. An exception creditor, could it also be another trust? In my family specific case, my wife and her brother have inherited their parents' modest rental properties and operate under an LLP with trust set up for their children to equally share upon the death of both current partners, my wife and her brother. However, with my daughter being special needs person with no reasonable ability to be an equal partner with her brother and cousins, my concern is she is at risk for possibly being in jeopardy of losing her SSI benefits, which would be the greater of the two.
Well, thank you. I completely understand your concern, and I sympathize with you. Not being able to give it legal advice over this webinar, I would just simply respond and say the facts and circumstances of that particular situation would have to be analyzed. And my hope would be if you are a person, and you're very thoughtful, I can tell just from the question, my assumption is that you have established a supplemental needs trust for your child. And my hope would be that because that trust is probably and hopefully established under the Maryland Discretionary Trust Act, that the Trust Act itself, by simply having that as the foundation of the trust, would protect your daughter's share from the claims of creditors, if that was the concern that I'm hearing. But not knowing the facts and circumstances 100%, I wouldn't be able to advise. But my hope would be that that is something that could give you some peace of mind that that if that's the structure for her, I would hope that she would have protection from the claims of, she certainly would have the claims of protection from the claims of creditors, but not knowing the exact structure of what has happened, I wouldn't be able to further advise. But my hope would be that in the end, you will have a happy result, that her protection under Maryland law through a discretionary trust would prevail.
Okay, thank you. Next question, does the corporate trustee charge a monthly fee to the grantor and or beneficiary?
Wonderful question. The corporate trustee is going to have a fee schedule, and then I think each institution is going to decide when those fees are payable. My experience has been, and I could be wrong on this, but my experience has been that the fee is paid once per year. But if the corporate trustee is managing the assets as well, that's something that we would have to look at on a case-by-case basis as to when the fees come out, whether it would be annually, semi-annually, or quarterly or monthly.
Okay. Next question, comment, seems like it may be beneficial, for example, for a revocable trust to have its own checking account. Will that previously established checking account persist when it becomes irrevocable after death of the grantor?
Great question. Great question. In the interest of time, I'll try to be efficient on this answer. So many people who create a revocable trust will either put their checking account into the revocable trust and make it a revocable trust checking account. And in some cases, clients will not do that. They'll say, I'm putting everything in my trust that I possibly can, but that checking account is going to remain outside my trust because I just don't want to put it in my trust. I've had this checking account for 30 years and I don't want to change it. So the checking account remains a little bit of a conundrum for some people. If the checking account is owned by the revocable trust, it's inside of the trust, retitled in the name of the trust, it will become irrevocable at the death of the grantor. If the trust does not own the checking account and the checking account is outside, then that will become a probate asset. And that's why we don't want to keep a huge amount of money in checking outside of a revocable trust. But what you can do, and hopefully many people will do this, is make it payable on death, especially if it's a relatively small account. Simply make that payable on death to beneficiaries if it's appropriate, and that will avoid probate, even if it's not in the trust.
Okay, thank you. Next question, can a trustee do the decanting or is it done by the grantor? What if other siblings have issues with the son/trustee chosen by me?
So there's 2 or 3 aspects of that question. In the interest of time, I would say my feeling about your question is the decanting cannot be done except by an independent person. So a good trust document is going to really address the issue of a special independent trustee that would be appointed for the purpose of decanting. So that's a complex subject. The other aspect, I think, of your question that I can answer is if there is a trustee that is causing lots of problems, or the beneficiaries or other siblings are not happy with that person, then I think the terms and provisions of the trust need to be carefully looked at as to what are the possibilities of removing that trustee or hopefully mediating that problem.
Okay. Can and do attorneys act as financial powers of attorney in addition to trustee and executor for a grantor who wants to reduce the burden on a spouse in the event of incapacity? Along those same lines by the same person, is there somewhere publicly available you can look up fee schedules for corporate attorneys?
So thank you for that. Yes, some attorneys, including us, we will act here at Elville and Associates as an attorney, in fact, under a power of attorney, and we do that often for people who don't have anyone else to appoint or see the attorney as the right choice for them. To my knowledge, there is no public website that lists generally the corporate fees of all corporate trustees or independent trustees in the state. But I could be wrong about that, but I have never heard of that kind of a central list. I've not heard of that.
Okay, and a couple more here. Does Maryland requirement for disclosure of trust details apply retroactively to older, quote, quiet trusts?
That's a great question. I would have to review the situation you're talking about. I think you might be saying, do the notice and information requirements are they retroactive prior to 2014? And I think the answer to that is no. That's a great question, though.
Okay, and pros and cons for trust being transferred from one state to another when one moves to another state?
That's a great question. So if it's a revocable trust, that trust should be moved. The situs, which is the location, and the state law should be changed to the new state, just generally speaking, if for no other reason than state income tax purposes. And then other ancillary documents such as powers of attorney and advance directives, if you're going to stay in that new state long term, those should be changed as well.
Okay. If there is no trust protector, is there a remedy for beneficiaries who feel the trustee is not acting as a fiduciary by the terms of the trust?
Yes, that's a great question. And the answer is yes. Of course, every situation is different. The document has to be examined, and then there has to be an analysis of what options are available. Sometimes not going to court, sometimes having to go to court. But hopefully a solution could be crafted, even if it's understanding the framework of having to go to court to ask for the removal of a trustee. But hopefully there's some mechanism in that document that would allow for the removal.
Okay, and last one, no, we're running a little bit behind here. Do most trusts allow distributions of income each year to beneficiaries? Beneficiaries pay the tax, so the trusts don't need to pay taxes.
Right, so that's a great question. So according to the terms and provisions of a particular trust, it's going to talk about whether income distributions are mandatory, but not all trusts require the distribution of income. But like you said, in many times, with some exceptions and depending on the facts and circumstances, a trustee is going to make a decision about the distribution of income, which generally is going to be a good thing depending on what kind of trust it is, and carrying out that income to the beneficiaries instead of paying the income tax at the trust level.
Okay. Okay, well, thank you all for your great questions. Thanks for being here today. Our webinar series carries on. Next Friday, we're doing special needs planning. Next Monday, we have an evening elder law and estate planning essentials. And then on the 8th, we have our advisors forum, our annual estate planning update with Steve. And so we're going to stay busy. And we appreciate you being part of our Elville webinar series here as we round out the week, and hope you have a great weekend. So thank you to Steve, and thanks for everybody for being here today. Have a great day. All right, bye-bye.